We've got stagnation in the court systems throughout California and the rest of the Ninth Circuit. We've got an 11% excise tax about to be imposed on California firearms owners. Let's talk about it. Hey everybody, welcome back to the channel today. Just kind of wanted to dig into an idea as we see some of these CRPA lawsuits sort of stagnated in the court system right now. Here to talk about this, we've brought CRPA's volunteer president, Chuck Michel, on. Chuck, thank you very much for being with us today.
Always a pleasure, guys.
Well, thanks again. And guys, if you want to directly contribute to Second Amendment litigation and legislative efforts here in California, please, as always, be sure to like, share, and subscribe to these videos. It really helps with the algorithms to get this information out there, and we want people to be informed as they go to the ballot box in November of this year for the general election. So, Chuck, actually, if I can set the stage for you really quick, we've seen CRPA lawsuits kind of being held up in the court system. This is an idea that we've sort of discussed in the context of specific lawsuits in prior videos, but I kind of wanted to dig into this idea of the Heller decision, which was a landmark Second Amendment case, kind of get perverted throughout the Ninth Circuit, and let's be real, in court systems all throughout the United States, created a necessity for a Bruin decision to be handed down. Kind of looks like there are attempts of that now. Is that what is stagnating some of these lawsuits? Can you just kind of dig into this idea, take us through the timeline, and give us what your opinion is and the reasoning behind some stagnation here in the courts?
Well, so you have to go back to Heller to understand the evolution here. The Heller case, and it's all about, by the way, the standard of review. It's what is the test that a court should apply in order to determine whether or not a gun control law or a gun ban is constitutional or not. And so typically that's called the standard of review, or the methodology that a court is supposed to apply in determining. It's the test to determine whether a gun law is constitutional. In Heller, they said, essentially, you get rid of all these historical tests, levels of scrutiny, like they used to apply or still apply in First Amendment cases, rational basis, intermediate scrutiny, strict scrutiny, all of that stuff was supposed to be thrown out under Heller. There was a dissent by one of the judges who voted against us on Heller that said, oh, well, we should just apply intermediate scrutiny. And that was specifically shot down. Basically, that's a balancing test where the judge can put their finger on the scale to find a law is constitutional, even if it shouldn't be. Heller was supposed to be a one-step test. You determine whether or not the conduct is covered by the Second Amendment, and then you apply basically a history and tradition test that Heller advocated, although not as clearly as it needed to. Now, the games that courts started playing with that was they said, well, the first step is whether or not the conduct being regulated is even within the scope of the Second Amendment right. And they said all Heller dealt with was guns in the home. So there was a whole argument about whether or not the Second Amendment only applied in your house. That's what they were saying the scope of the Second Amendment was. And then it's only for self-defense guns, not for anything else like hunting or sport shooting or any other activity that you could lawfully use a firearm for. And so the courts distorted this standard of review, and the Ninth Circuit really kind of epitomized that with their Duncan decision the first time around. And remember, that went en banc, and we lost 7-4. So we needed 2 votes to shift it over to 6-5, but we didn't have them. But the point is, there was 4 votes even then for us to win. Okay, so Duncan goes up to the Supreme Court. It sits there waiting for Bruin to be decided. When Bruin came down, they said, look, this 2-step test that the lower courts are applying, that's 1 step too many. You're not supposed to have this 2-step test. It's simple. Does the language of the Second Amendment cover the conduct? Is it a bearable arm? Is it some kind of related conduct, like going to the range or hunting or getting your gun repaired or any of the associated activities that go along with gun ownership, practicing, marksmanship? And then if it is, then the burden's supposed to shift to the state to prove that there is some historical tradition some kind of law in the past from 1791 when the Bill of Rights was ratified that would indicate that the modern law would be tolerated by the founding fathers, the colonists that ratified the Second Amendment. That's supposed to be the test. But even now, that is being twisted, and they're trying to again do this two-step test. So what's going on here is some judges are being faithful in reading both Heller and Bruen, and others are not because they do not like the Second Amendment. They do not want the state to be limited in what it can regulate, what kinds of firearms or related conduct it can regulate. And so they're biased. There's a rampant bias going on in the lower courts still. It took us 12 years to straighten it out after Bruen. At least we thought we straightened it, excuse me, after Heller. At least we thought we straightened it out with Bruen, but the courts are still resisting. And so depending on the judge that you get, that judge will either faithfully apply the Bruen test. He will admit that he or she, as a judge, is bound by what the Supreme Court says, or they will try and fight it by distorting the language of Bruen and turning it into something that it isn't. And the way they're doing that, by the way, is all being put together by lawyers for Michael Bloomberg and Everytown Law. This is not individual attorney generals' offices coming up with this stuff. This is being masterminded and funded by a billionaire who is a social engineer and wants society to go the way he thinks is smarter, which is government tells you how to live your life and you don't really make any individual decisions. You do what the government says. So that's where we're at. The courts have been twisting the Bruen methodology to try and uphold gun control laws, but with a lot of notable good exceptions where district court judges and some circuit courts, Fifth Circuit in particular, are faithfully applying Bruen and striking down gun control laws. So we're in the Ninth Circuit again with Duncan back in front of the en banc panel, waiting to see what they do there, and then we're also waiting to see what the Supreme Court will do in the Rahimi case and see if it straightens out the lower courts again. Really, they need to be slapped down and told stop playing games and do what the Supreme Court says you have to do. You're bound by Supreme Court as the Supreme Court. You're an inferior court. You're bound by what the Supreme Court says. So do what we said. Stop twisting everything.
So is that essentially what it comes down to? Because it seems like everybody is just sort of holding their breath right now. So, I mean, it basically sounds like what you're saying is we're kind of going through the same thing with Bruen that we went through with Heller as far as personal preference or political ideology becoming a thing with judges who might not, at the onset, like the Second Amendment or want to see people have those rights. Going back to December of last year, and especially January and February of this year, we had a lot of movement of these lawsuits. You're talking about the May case with the sensitive places. You're talking about the Crossroads lawsuit with the gun shows, and then Judge Benitez dropping Duncan and Rhodey, which was ammunition and standard capacity magazines, all at the federal district court.
And Miller on semi-autos. Yeah.
Right. So, but now it seems like what you're saying is that these lower courts, that being the Ninth Circuit and maybe even the federal district court, aren't seeing a lot of movement in these cases. They're kind of holding their breath, waiting to see if they're going to get slapped down by the Supreme Court.
The Duncan en banc panel probably is. All the other three-judge panels are waiting to see what the Duncan en banc panel does. So the leading case in the Ninth Circuit right now is Duncan. That's already been argued en banc. That's the magazine. That's CRPA's magazine capacity challenge to the magazine capacity ban. So that's 11 judges. The other panels, the other cases are in front of three-judge panels. So we're waiting. They're kind of bottlenecked, just like they were before Bruen came down. They were all bottlenecked behind Duncan, and they are again. So hopefully the Supreme Court will either take a Second Amendment case and there's like 6 of them up with a request for a grant of certiorari. The Supreme Court has the discretion to take or not take a case. So hopefully they'll take one or more of those cases that are in front of them and they're deciding on May 16th. Or they will make it clear in Rahimi that the courts are twisting Bruen and they should straighten them out. But yes, it's the methodology, and depending on the judge you get, they adopt the proper methodology that Bruin commands, or they twist it to try and uphold a law that under Bruin should be unconstitutional.
But I guess it sounds like while some of these cases have stagnated a little bit, what you're saying is there are a couple of things on the horizon that could potentially come back and make them no longer static. So right. So as long as that gets straightened out, if we can, I'd like to shift really quick to something that has been signed into law, but there are no lawsuits on it yet. I've been getting a lot of questions on Assembly Bill 28. That is the implementation of an 11% excise tax on, and correct me if I'm wrong here, Chuck, the tax is actually imposed on firearms manufacturers, while we can probably see in a lot of instances those taxes end up trickling down and being paid for by the consumer.
Retailers will have to charge the tax too if the it's not as straightforward as it should be, but you may wind up seeing on your receipt for a firearm or a magazine or ammo, state mandated 11% excise tax, and it's just tacked on as another tax, like sales tax or whatever. But the bottom line is, one way or another, consumers are going to wind up paying it, whether it gets passed through by the manufacturer to the retailer or charged directly by the retailer. Consumers are going to wind up paying it. And no one wants, everybody, we all want to file a lawsuit against this law. The National Shooting Sports Foundation represents manufacturers and retailers, and they have the funding. They're ready to pull the trigger. They have lawyers lined up. They're ready to do it. The problem is it's not a clear Second Amendment case because of the nature of it as a tax. And there are a lot of tangential issues, and this happens sometimes. You get involved in a lawsuit, and you wind up spending tens of thousands of dollars litigating some side issue like standing, or whether your case is a facial or an as-applied challenge, that just costs a lot of money and wastes a lot of time. One of the issues that's slowing down the filing of a lawsuit is there's a doctrine that says in order to challenge a tax, you first have to pay the tax. So the tax doesn't get assessed until July 1st. So we have to, before we can even have a viable plaintiff and not have to have this argument about whether or not you have to pay the tax first or not, we can save a lot of money by just seeing if we can file a suit after someone pays the tax. Now, even then, it's not as straight up. It's not quite as straight up, legally speaking, based on the case law, as a poll tax would be, where somebody had to pay a fee to go vote. So it's not as simple as you might think to challenge this tax. That said, if there's a way, we have the will and the funding, so it will be done. It's just a matter of coming up with a winning strategy and not getting bogged down and sidetracked on a bunch of tangential issues which don't need to be litigated right now. We don't want to waste the time and the money litigating something that doesn't get us to the ultimate goal, which is to strike down the tax.
I'm sure a lot of people who were paying attention to a lot of the lawsuits surrounding the 2020 elections can at least be familiar with the idea of standing, as you saw a lot of lawsuits get thrown out for that very reason. And I guess, you do definitely want to have a winning strategy as you go into that. Definitely something that we're going to follow along and pay attention to. Chuck, I guess just to wrap this up, what's the view going forward? What is the path going forward with some of the stagnation in lawsuits in California and the Ninth Circuit right now, as well as the AB 28 tax?
We're still litigating those Second Amendment lawsuits. We are anxious and willing and desirous to sue over the excise tax. But the Second Amendment issue on the other lawsuits, there's been some great recent decisions. We just got a decision from the Ninth Circuit 3-judge panel that said that a nonviolent felon cannot be charged and convicted with possessing a firearm based on his nonviolent felony conviction. That was a pretty big win. That's 2 judges in the Ninth Circuit that said that. The state has already asked for en banc review on that one, so we'll be bottlenecked behind that. And then CRPA and Second Amendment Law Center are working with some other groups, GOC, Second Amendment Foundation, Gun Owners of America, to file an amicus brief in a case where a criminal defendant was charged with possessing a fully automatic firearm. And the lower court in Oregon, the district court, federal district court judge, didn't even get to the Bruin historical tradition test. She just said fully automatic firearms are not covered by, they're not arms that qualify protection under the Second Amendment. And that's wrong. So however this comes out, and courts are, given the uncertainty and sort of the different opinions that are coming down on how the Second Amendment should be tested in the Bruin methodology, it's not surprising that judges are not going to strike down a machine gun law yet. But that said, they have to at least apply the test correctly. And all firearms, all bearable firearms, are arms covered by the Second Amendment, whether they're fully automatic or semi-automatic or whatever. The question is not whether or not they're covered by the text of the Second Amendment itself, whether they're qualifying arms. The question is, are they dangerous and unusual so that they can, or are they in common use? If they're dangerous and unusual, they can be regulated and potentially banned. But the district court didn't go through that proper test. So we're filing an amicus brief laying out, this is the analysis that you have to do. We're not necessarily saying how it should come out, because we don't know all the facts of that particular case, but you at least have to do the test right. And this is, again, goes back to what we started this conversation with about the courts perverting the test to achieve the ends that they want by manipulating the language of the Bruin decision in a way they think they can get away with and get a ruling that they want, which will be to uphold most gun control laws. So that test applies no matter what kind of firearm it is. You got to apply that test faithfully. And it may very well be that fully automatics is where the line are drawn. We don't know. We certainly believe that all arms, no matter what action type, are covered by the Second Amendment. And then the second phase under the Bruin test is the state has to show that there is some historical tradition for regulating a certain type of firearm. And that's typically looking for an analog law, a historical law that is analogous to the modern day law that would show that the founders would tolerate banning whatever modern day arm it is they're trying to ban. So the game is still afoot, is basically what I'm saying. There are decisions coming down every day. We are helping other groups and public defenders with their cases, because there will be some precedent coming out of criminal case decisions, even though all CRPA's cases are basically civil rights cases. But so there's, and then all the cases that we still have, minor marketing ban, the gun show ban, those are all still being litigated, and we have new ones queued up. We were ready to go on the 1160, and folks should really pay attention to what that bill would have done. Taxed every single gun owner, registered every gun owner, registered every single gun, not just semi-autos, every single gun. And then you would have had to pay a tax on every single gun that you owned every single year. And if you missed a payment, your guns get confiscated and you could go to jail. Now, thankfully, between the advocacy from CRPA, GOC, some other groups up there in the Capitol, the author of that bill realized that was a bridge too far. But don't think they're not going to try and cross that bridge someday as soon as they can. They will. So the stakes are high, and their agenda is now out in the open. And all this other stuff that they're doing is, just a step towards their ultimate goal. And that really is almost practically civil disarmament. Almost no one will have a gun, and you won't have very many guns, and you won't have very many rounds of ammunition, and you won't be able to use it in very many places.
Yeah, I guess it's you don't want to be in the second installment of Death by Gun Control, which is essentially a book, talking about the 100 million people that were murdered by fascist dictators who implemented this kind of legislation exactly. Chuck, really quick, before I let you go, I got to ask, because we've gotten questions on this too. You mentioned the Duarte lawsuit. Why would so I mean, I guess generally speaking, we're preconditioned to think bad when we hear the word felon. So this is the lawsuit giving nonviolent felons the right to possess and own firearms. Why would a Second Amendment advocate consider it a win to give felons Second Amendment rights?
Good question. First of all, not all felons, non-violent felons. Just like the test should be an individualized determination of dangerousness. Not all felons are dangerous. There's a lot of drug convictions that are felonies. There's a lot of fraud or welfare. There's all kinds of paperwork violations that can be all kinds of crimes can be felonies. They're not just the armed robbery, which is that's a bad guy. He should be disarmed because he's dangerous. And that's what the Supreme Court was saying in the Rahimi oral argument. They were looking for a finding of dangerousness. But if you allow the government to blanket ban classes of people, whether it's felons or cannabis users or someone with a TRO that they may not necessarily even realize they have against them, all you do is enable the government to disarm a politically disfavored class of people. And the way they've done that in the past, in history, is they disarmed freed slaves, they disarmed Native American Indians. At one point, they disarmed Catholics. Yeah. I mean, if you let a class of people be disarmed like that without an individualized finding of some kind of a threat from that person, but just blanket take away the right to keep and bear arms from a group, then any group can be disarmed, including patriots, whatever that means, or MAGA people, or any group that the current government decides they characterize as a threat, through whatever propaganda they want to use to demonize a subclass of people. You just give them the power to disarm broad swaths of the populace that the government doesn't like for political reasons.
Well, yeah, and the way that the media goes nowadays, it can really get spun whichever way you want it. So thank you very much for that clarification. A lot of potential here and a lot of stuff to follow along. Obviously, as a channel, we're going to continue to follow along. Probably have you back real soon. I know you're a busy guy, though, Chuck. I want to thank you for coming on and giving us that insight.
Always happy to make time for you guys. Thanks for getting the word out.
Absolutely. And guys, if you like content and want to see more videos like this, if you want to directly contribute to Second Amendment litigation and legislative efforts here in California, please, one more time, be sure to like, share, and subscribe to these videos. Hit that little notification bell so that when we drop these videos, they hit your inbox immediately so that you can pass that message on to those around you. Thanks, guys, and we'll see you on the next one.